All right, legal analyst Melusi Xulu joins us now to unpack today's proceedings in this case and other cases. Thank you so much for your time, Melusi. So, of course, I want us to start with the Senzo Meyiwa case very briefly. I mean, this after the state in the Senzo Meyiwa murder trial has rested its case. So, after 3 years of testimony, did the state prove its case beyond reasonable doubt, you think?
Good afternoon to you, Night and the viewers at home. I think at this point, there are certain issues which one will have in mind. For instance, I was interested to find out whether Kelly's mother will testify. And there's also, I think, a Mary Peary who cleaned the scene. But the defense is at liberty to call those witnesses. But what is important is, do they have a case which they can say they prove beyond reasonable doubt? At this point, I think we have not really finished. They still need to argue. And the witnesses, the accused will have to testify. So I think it's too early to call it and say they've proved it beyond. Let's wait and see whether the accused will be able to defend themselves first. But I'm aware that they might want to apply for Section 174 before anything else happens.
Especially now that the defense is saying that it will bring an application for the charges against the accused, in fact, to be dropped. But let's turn our focus now on the murder trial of Keenan, aka Forbes, and his friend Tibelo Tibbs Mutswene. Among Judge Jacqueline Hendricks, her statement ordering the state to now get its house in order after it failed to furnish the defense with particular documents. I mean, what does this do then to this particular case? And just the words that have been echoed there by the judge, what does this mean for this particular case?
Well, it means that they're not as ready as they should be at this point. It's a high-profile case, so everyone's eyes is on this case. I think they should have had their house in order. But basically, these are things that do happen at times where you'll find that, when the matter is ready, inverted commas, for trial, there'll be certain issues that the defense will say they have not been furnished with certain documents or certain evidence that needs to be given to them. But I think at this point, it's better that at least these issues are dealt with, because there is the purpose for pre-trial. The purpose for a pre-trial is to narrow down issues and find out things that are necessary to be given to the defense and things that are unnecessary and things that the defense and the state can agree on. So I think it was important that these issues are clear and are dealt with at this point rather than later.
Yeah, I mean, when you look at, in fact, the material that was not supplied, one would think that this is standard material that should have actually been furnished. I mean, we're talking here about documents related to ballistics results, CCTV footage evidence, bank statements of the accused, and quite importantly, affidavits of 45 witnesses whom the state is expected to call to the stand.
Yeah, I was circumspect to spell it out tonight, but let me just address that then, because it's an elephant in the room. Those are basic things. Your 45 state witnesses, those are basic things. Ballistic reports, because this matter involves a gun or guns, it should be already available before we even talk about a pre-trial. Those are the things that they should say they've investigated, they've got everything, and then they should finish the defense with everything that they need. Because remember, to prepare for your trial is a constitutional right as well in Section 35. So I think there is a concern. It should be a huge concern that, such information and evidence has not been given to the defense, and it puts the reputation of NPA at a position where it looks like they are not prepared. But hopefully, like I said earlier, these things are being addressed at this point. And hopefully later on, when they come back on the 13th of August, everything will be ready so that the matter is not delayed any further.
And what's the significance of the judge ordering that media houses who were previously allowed to record and to broadcast the court proceedings now not doing so, particularly as you've said also earlier on, that this is a high-profile case?
I think we've dealt with situations like this before, where the media can apply for this matter to be broadcasted or to have their rights to for media information or freedom of expression, which is in the Constitution. So I think maybe the judge is trying to protect it a bit, so that it's not shown, so that everything is not shown. But it's up to the media outlets whether they want, full access, and they can still apply for that because it is in the public interest, which makes it constitutionally important that everyone can see what happened in this case. So I believe it's up to the media if they want full access.